Before we get started, I want to do some housekeeping. First of all, I'm Shelley Richardson, the Executive Director of the Statewide Independent Living Council. We're going to wait to take questions at the end, but if you would like to go ahead and type out your questions as the presentation is going, you put them in the question and answer area, then Tara will help us field questions at the end. If you have any technical problems, if you will use the chat for that instead of the question and answer, we'd appreciate that. So we have ASL today, as well as live transcription interpreting. So with all of that being said, I'm going to turn it over to John Herring and let him introduce himself. Oh, I forgot to give my description, or did I?
You did not.
I did not. Okay. I'm a middle-aged white female with short red hair and glasses, and my preferred pronouns are she and her. Thank you.
Again, good morning. This is John Herring. I am the Executive Director of INCIL, the Illinois Network of Centers for Independent Living. I'm happy to co-host this webinar with Shelley and Silk. I am an African-American male, very short haircut with glasses, and I am sitting in my office with a very black and gray sweater on. Again, we want to just thank you for joining us this morning. Yet to reiterate, if you have any questions during the presentation, put them in the chat. We will answer them at the end. And now it's my pleasure to present the presenters for this webinar. Jocelyn Rios is from Hope Fair Housing, and Foluke is from Housing Action Illinois. Jocelyn.
Thank you so much, John. Good morning, everyone, and thank you for joining us. As John mentioned, my name is Jocelyn Rios. I am the outreach coordinator here at Hope Fair Housing Center. Just an image description as well. I am a Latina woman with long black hair, glasses, wearing a orange cardigan and a gray shirt, and I'm in a white background. So thank you all for joining us. I know a lot of us are here today to kind of go over source of income. We're going to kind of have this presentation in two parts. So I'm going to start off by just going over some general fair housing to kind of set the foundation for all of us here today. And then I'm going to pass it over to Foluke in our second half of the presentation to talk more in depthly about this new source of income protection that went into effect earlier this year. So just so you all know kind of what that agenda is going to look like, and so you can kind of be prepared of when we actually get into source of income, because I know that is something that a lot of you have shown interest about. So just so you're all prepared. So I'm going to go ahead and get started with the presentation here. So just as a disclaimer, we're really just here to provide really just resources, education, materials, and really inform people about their fair housing rights. And really all the information that we're presenting on here today is not intended to be used as legal advice. Foluke and I are really pretty knowledgeable about all the material that we're talking about today, but again, we are not lawyers. So we just want to make that very clear when we're talking through this presentation, that if there's any specific matter or scenario that may be occurring, to definitely consult a lawyer. We're just really here to provide knowledge and resources to all of you here today. So I'm just going to go ahead and get started. So for those who do not know about Hope, I just wanted to provide a little bit of what we do and what our mission here really is and what we stand for. So we're really just here to create greater housing opportunities for all. We want to ensure everyone has the chance to live in the place of their choosing, free from any illegal discrimination. So on this next slide, you'll see our service area map, and I'll also give a description of what that map looks like. So it's just a map of Illinois with all the counties on there. Some are shaded in blue, which will be our service area, or quote unquote service area here at Hope, and others will be shaded in gray. So we serve over 30 counties here in northern and north central parts of Illinois, but we're also in the process of expanding our services to areas in southern Illinois. Foluke has been a part of that journey with us here at Hope in ensuring that we hit these areas that may have little to no fair housing resources this year, as well as the end of last year. Even though we have a service area map, the areas in gray that are not shaded aren't technically in our service area, but we typically don't deny anyone who is seeking fair housing assistance. So definitely call Hope if you are in that situation, or those that you work with are in that situation. I would say definitely do not hesitate in calling. If we can't resolve the matter, we'll definitely provide you with referral to the entity that would be best equipped to handle that matter. So yeah, just our service area map that I wanted to share. As I mentioned, I'm going to sort of provide this foundation for us to kind of talk about when we're discussing fair housing. And it's important to kind of go into what the history of housing and fair housing and what that looked like prior to the Fair Housing Act. And the best way to do that is to simply just touch on these discriminatory practices, and these we're seeing prior to the passing of the Fair Housing Act, and in some way, shape, or form are still have some sort of effect on how we see our neighborhoods and our state today. So things such as redlining, restrictive covenants, contract buying, and predatory contracts. But for the bulk of the presentation, we're really going to focus on that discrimination portion, really just the treatment of treating someone unfavorably based on the group to which that person belongs to. Again, I think it's still just important to highlight these practices because they still have some sort of effect on how we see our neighborhoods, our cities, our state, our counties today. So as I mentioned, the Fair Housing Act really allows us here at Hope to do the work that we do. I just want to provide you all with the definition of that, and it's really just having the Fair Housing Act in place prohibits discrimination in renting, leasing, buying, selling, or occupying a dwelling because of a person's membership in a protected class. And we'll get into what those protected classes are in a couple more slides down. But the best way to remember this, and how I like to remember a protected class, is just remembering that it's just common characteristics that people share with one another. And hopefully that sticks with all of you, and it'll make more sense once we actually see what those protected classes are at the federal and state level. So this on the screen here is a map, and it's a Hulk map. And so just to provide an image description here, this is a map of Springfield, and it's from the 1940s. So the background is all white, and then areas are shaded in red, yellow, blue, and green. And so these maps that are, these Hulk maps that we like to call them, really just show how loan officers would evaluate mortgage lending. And so each color that's on the map would have has a different sort of description of how good they are and how much mortgage lending was done there. So areas that are in green, so that would be more on the, how I'm looking at the screen is on the left-hand corner. Those areas were considered to be the best areas where the most lending was done. From there, it kind of would go down. So areas in blue, were still considered good areas. So some mortgage lending was done there. Once we hit those yellow areas, which is part of the middle of the map, and then some areas down below on the left-hand corner, those were areas that were considered to be on a decline. So loan officers and appraisers would really try to evaluate whether mortgage lending was appropriate or if it was too risky to be done there. And more in the center and right-hand side of the map, the areas in red were considered hazardous. So absolutely no mortgage lending was done there. Again, I think these are just important to highlight because, as I mentioned early on when we're talking about those discriminatory practices, although they may not be as evident as they once were, the lingering effects of them still might be present today. So what is fair housing? It's pretty simple once we actually break it down a little bit. I know I gave you all that definition. So breaking it down a little bit further so that we understand it, but really it's just the right for people to live where they choose, have access to housing, whether you're in the process of searching for it, you're renting it, or you're buying it, and really be able to utilize and enjoy your home to its fullest potential. And this should come without any form of unlawful discrimination, interference, coercion, threats, or even intimidation. So we're going to take a deeper look now into fair housing, and the best way to do that is to identify the different kinds of discrimination. So for the first half, we're going to talk about direct discrimination. So that's really just treating someone less favorable than another based on their membership in a protected class. And then later on, once we talk about arrest and conviction and eviction records, we'll get into what disparate impact is, but I think it's still important to highlight that definition for you all. And disparate impact is really just having a policy in place that on the surface seems neutral, but when it's actually put into practice has a greater negative impact on one protected class over another. So as I mentioned, when we're talking about what the Fair Housing Act is, I mentioned that word protected classes, right? And so under the Fair Housing Act, we have 7 protected classes: race, disability, sex, national origin, color, religion, and familial status. In Illinois, under the Illinois Human Rights Act, we have additional protections that protect those here in the state. So sexual orientation, ancestry, marital status, gender identity, age, the list continues. And as I mentioned at the beginning of our presentation, source of income is one of the newest protections that was added to the Illinois Human Rights Act. And so we're going to talk more extensively about that later on. But just some things to note with these protected classes. Recently, sexual harassment, sexual orientation, and gender identity are covered now when we're talking about the federal protected class of sex, because the Biden and Harris administration had issued this guidance interpreting that these additional protections would cover sexual harassment, sexual orientation, and gender identity. That, however, could change depending on who we have, what administration is in place. So that's one thing I wanted to highlight from the federal protected classes. Another thing that I think is still important to talk about, the Immigrant Tenant Protection Act is separate from Illinois, the Illinois Human Rights Act, but still important as it does affect a lot of individuals here in Illinois. But this law really just prohibits housing providers from harassing, threatening, or even evicting tenants based on any perceived immigration or citizenship status. Again, just highlighting the fact that this is separate from the Illinois protected classes under the Illinois Human Rights Act. So yeah, I wanted to start off by showcasing these federal protections and state protections. And then we're going to discuss what a prohibited act is. And this really ties into when there is a fair housing discrimination case or if there's a potential fair housing violation in place. So that's why I'm providing you all with the protections first and then the prohibited act. You'll kind of see why in the next slide. But A prohibited act really is just any sort of act or instance in where a person is harmed, treated differently, that would deny them housing or the ability to enjoy their housing. So I'm sure we've heard of things such as steering, only showing certain units or certain buildings in a certain area to people who may look the same as them, simply refusing to rent to someone or lying about the availability of housing, charging additional or higher fees, discriminatory ads or statements, things like that would constitute as a prohibited act. And as I mentioned, we're all probably wondering, okay, so we have this sort of basis of what fair housing is, but when does it actually come into play? How is it potentially, how could it potentially lead to a fair housing violation? So as I mentioned, if we have a prohibited act and we have a protected class, any of the ones that are listed at the federal level under the Fair Housing Act or the state level under the Illinois Human Rights Act would potentially lead to illegal discrimination. So here we have an example of just what that might look like when we're talking about direct discrimination and also when we're talking about disparate impact. So the first example is just, a landlord simply refusing to rent to someone because they have children. As I mentioned, the Prohibited Act, one of the first ones listed on there is simply the refusal to rent to someone. And in this case, the protected class would be familial status. So simply because someone has children, the landlord's refusing to rent to them, that would potentially lead to a fair housing violation. In a disparate impact example, a housing provider may refuse to accept disability assistance to pay for rent from tenants with a disability. So we all know that disability is a protected class under the Fair Housing Act. So refusing to accept the disability assistance would be that prohibited act, would potentially lead to a fair housing violation. And we wanted to include that because obviously the source of income is a new protection. And again, we'll get into more of the details of that later on, but I just wanted to highlight that example as well. So in the next slide, I really just wanted to provide this sort of scenario so we can kind of see it. So we can kind of use that equation that I mentioned early on, where you have a prohibited act and then you have a protected class. Is there a potential fair housing violation, or are we able to identify what that prohibited act might be? So I'm going to read it off, and then I'll kind of go into the details of identifying the protected class and identifying the prohibited act, and then if it's a potential fair housing violation. So Mary is searching for affordable housing in her neighborhood. She is unable to work full-time due to her mental health disability, and she receives disability benefits to cover her living expenses. While on a scheduled tour of an apartment, Mary mentions she'll be able to put down a security deposit by the end of the week, as that is when she will have the money deposited into her account. The landlord informs Mary that he doesn't accept any Section 8 or anything else from the government for rent. So in this case, as we saw in the previous example, when I was kind of going over that, excuse me, going over that equation, we saw a similar example. So simply because Mary is using her disability benefits to cover her living expenses, such as her rent, and the landlord prohibiting her by saying that he does not accept any form of Section 8 or anything from the government, Mary being protected by disability as a protected class, also source of income now under the state law, this could potentially lead to a fair housing violation. So here we have another scenario. So Brianna has been residing in Maple Oaks condominium for 4 months. Last Tuesday, a property management team member sent her a suggestive text message. Uncomfortable but not wanting to cause any problems, Brianna ignored the message. Today, while she was opening the door to her unit, the staff member appears, pressing her for a sexual favor. When she refuses, he threatens her with eviction unless she accepted his advances. So as I mentioned, now sexual harassment is covered under the federal protected class of sex. So we know that that's the protected class. In this case, the prohibited act is the staff member threatening a potential eviction on Brianna simply because she is not accepting his sexual advances. So having those two would potentially lead to illegal discrimination, potentially have a fair housing violation in place. So now we're going to look at discrimination in a protected class, and we're really going to focus more on just that disability as a protected class under the federal protection, since we're all, since everyone here is from SILS, I think it's important to just highlight those protections and additional protections, not only under the Fair Housing Act, but other protections that we see. So when we're talking about a disability, when we're talking about fair housing, what exactly is covered? So that would be any mental or physical diagnosis that would substantially limit one or more major life activities. So breathing, walking, seeing, hearing, learning, any of the others on the screen, like performing manual tasks or self-care, or the discrimination on the perception of having a disability. And we'll talk later on about what a perceived protected class is, and what that might look like. When we say substantially limit, we're referring to that individual's disability limiting their ability to really utilize and enjoy their home. So, or even interfere with their ability to meet requirements of the lease agreement. So, if, for example, someone is blind, they may not be able to read or comply with a written notice unless it's provided to them in Braille. Temporary disabilities are evaluated on a more case-by-case basis, still using the same criteria that I just mentioned. All right, so under the Fair Housing Act, there are certain additional protections for the disability community that I want to touch on first, and then we'll kind of go into Section 504 very briefly. But under the Fair Housing Act, there are what we call design and construction requirements for that really impact those who have disabilities. And these requirements, excuse me, sorry, really impact any sort of dwelling that is designed and constructed for first occupancy after March 13th, 1991. So that date is important to remember when we're thinking of these design and construction requirements. Just wanted to highlight that, but on the screen, there are 7 different requirements, and I'll go over each one. So just an accessible building entrance on an accessible route, accessible common and public use areas, usable doors. So thinking of, is it actually usable for a person who may be in a wheelchair? Accessible route into and through the dwelling unit. Again, thinking of that person that may be in a wheelchair. Any sort of light switches, electrical outlets, thermostats, and other environmental controls in accessible locations. So are they a certain height off the ground? Are they still able to be reached? Again, thinking of that person in the wheelchair, I should say. Reinforced walls in the bathrooms for later installation of grab bars. So we're really just focusing on the walls here, because as we'll talk about later on, the grab bars are seen more as a reasonable modification. And again, usable kitchens and bathrooms, similar to just being able to access them like the unit itself. Oh, I skipped one. So now we're going to talk a little bit about the Rehabilitation Act. And really, this is just one of the first laws that extend civil rights to individuals with disability. And really, it just applies to those who are receiving federal financial assistance as well. So keep skipping a slide. Sorry, everyone. So just some of the key features that I want to mention when we're discussing the Rehabilitation Act is that when it comes to housing, it really just covers any housing that receives federal assistance, such as Section 8, public housing, or even subsidized housing. Mandates that at least 5% of units be designed for persons with physical disabilities, and that 2 be designed for persons that are deaf, hard of hearing, blind, or have low vision. Additional standardizations per the Architectural Barriers Act really just states that buildings that are built for or leased to federal government must be physically accessible as well. So still sticking with that protected class of disability, we're going to talk about reasonable accommodations. And here at Hope, we really, I think reasonable accommodations are one of the calls we get the most of in terms of advocating and assisting individuals who may be facing a fair housing violation. And so really, it's just a change in a rule, policy, practice, or service that is necessary for a person with a disability to have an equal opportunity and really use and enjoy that housing. When we're discussing reasonable accommodations and we're bringing up that request for the accommodation to a housing provider, it's important to note that the need and the request must come from the person with a disability themselves. So the housing provider must be made aware of that disability. However, if it's a visible disability, a housing provider cannot ask for confirmation. If it's an invisible disability, so for example, anything that may be sort of a mental health diagnosis, things that may not be super apparent, a housing provider can ask for a third-party verification for that requested accommodation. So third-party verification could simply be a medical or therapeutic professional providing that sort of verification to the housing provider. And it's important to note that the housing provider can and should never ask for that, ask the person with the disability what their disability is. So that third-party verification is simply enough for that accommodation, and if it's deemed reasonable. So some of the common accommodations that we get calls about and that I'm sure most housing providers get asked about are assistance animals. So on the screen, there's a picture of a service dog with a person who is in a wheelchair. So allowing tenants with disabilities to have an assistance animal, accessible parking for tenants with a disability, the image on the screen as well. You could see the accessible parking with the disability placard on it as well. And then one that is interesting that I think it's also important to note is allowing a tenant with a mental health disability, which affects other residents, to get medical treatment before deciding to evict them. So these are just some of the examples, but they're probably the most common ones we see, especially when we're dealing with assistance animals and tenants looking to request an accessible parking space, right? Just things to note when we're talking about assistance animals is that obviously, as we may all know, assistance animals provide a service, so they're not deemed as pets. So even if a housing provider says that there is a no pet policy, that's where a reasonable accommodation would come into place. You know, this assistance animal is really there for the person and their disability and really allowing them to utilize and enjoy their housing. So again, that's where that reasonable accommodation could come into place. Going back to when I was talking about prohibited act, so charging a pet fee would also, if that is a policy that a housing provider has, again, an assistance animal isn't a pet fee, so, or isn't a pet, I should say, so providing or adding on that fee to that person who's looking to live there with their assistance animal could potentially be a fair housing violation as well. So those are just some of the things I wanted to note when we're talking about these reasonable accommodations and these examples. And yeah, now I'm gonna switch gears a little bit and talk more about reasonable modifications. And these are pretty cut and clear and to the point. So really it's just an actual physical change to the premise that would be at the expense or the cost of the person with the disability. So I mentioned pretty early on the image. One of the first images on the screen is a person holding a grab bar in the bathroom. The second is the doorway, so showcasing the wideness of it, so widening the doorways. And then the third picture here is the outside of the house with a ramp that is leading up to the door. So installing wheelchair ramps would also be reasonable modifications. Again, these can be costly, so it's important to remember that these costs would be at the expense of the person with the disability. So again, I am going to go into another scenario here. I'll read it out loud and then keep skipping slides. So I'll read it out loud and then I'll just kind of identify the protected class and the prohibited act, and then kind of share if there's a potential fair housing violation. So Shirley has a physical disability. She is looking for an accessible apartment in her neighborhood. While she's inquiring about a unit, she asks the rental office if there's an accessible parking space available and what the process would be to request a reasonable accommodation for her service dog. The property management staff states that there is plenty of parking available to all residents in the back of the building and that it's at first come, first serve basis. Additionally, there is a pet fee of $75 that she must add to her security deposit and application fee in order to have the service animal in the unit. So a lot of what's in the scenario I mentioned a couple slides ago, but we know that we were talking about disability as a protected class. So we already know what the protected class is going to be, disability, because Shirley has a physical disability. And then simply denying the person that reasonable accommodation. So again, charging that pet fee, which as I mentioned, the service animal is not a pet, it's providing a service to that person. That would potentially lead, that would be the prohibited act. Having that protected class and the prohibited act would lead to a potential fair housing violation. All right, so this is the last slide before I'm going to move on to disparate impact and talk about arrest and eviction. But when I was talking about disability, I mentioned the word perceived protected class, and associational and perceived protected classes are not as, I wouldn't say as common or maybe not as evident that we would see direct discrimination when it comes to protected class, but I think it's still important to highlight what those might look like because it can happen. People may not be aware of it. So when we're talking about a perceived protected class, one of the examples we like to give is a landlord treating a woman who they perceive to be a lesbian because she does not act or dress like a normal straight woman. So regardless of if this woman is actually a lesbian or not, she is being treated differently because of the because that landlord is perceiving her to be that way. So again, simply because she may or may not be a lesbian, the landlord is treating her differently. Having that sort of differential treatment could potentially lead to a fair housing violation. Because as we saw, sexual orientation was covered not only at the state level, but also at the federal level. An example of an associational protected class, this one's a little bit different, and it can affect two different parties here. So a white tenant inviting their Black friends to visit and a landlord banning them despite any negative issues or interactions occurring. So not only would the white tenant have a potential fair housing violation, but also the Black friend who were racially discriminated against by this landlord simply for nothing, as it was mentioned here. And then the white tenant would have sort of a different fair housing complaint. The white tenant would be sort of denied that opportunity to live in this sort of diverse environment or be around this diverse environment because of the landlord banning their friends from living there. All right, so disparate impact. I'm going to try to get through this sort of chunk of the slides quickly so we can discuss source of income. But disparate impact, as I said early on, but I just want to refresh everyone's sort of memory on what it is a policy that is neutral on its face, but when it's put into practice has a greater negative impact on one protected class or group more than another. So we really see a lot of disparate impact when we're talking about arrest and conviction records and also evictions. So I first want to talk about arrest and conviction records. And so it's important to highlight that it's not a federally protected class. Under the Illinois Human Rights Act, arrest record status is protected, and that protection extends to any arrest that an arrest not leading to a conviction, a juvenile record, or criminal history record, information ordered expunged, sealed, or impounded. However, when we are looking at arrest and conviction records, when we're talking about fair housing and how it could be a disparate impact matter, we're really focusing on the screening process and how that may violate civil rights laws. So this is just a really good example of a case law that allows us to kind of take on these cases when we're talking about disparate impact and arrest and conviction records. And so Fortune Society is a nonprofit organization that would help formerly incarcerated individuals and people with arrest and conviction records sort of re-enter society and would kind of seek out housing for them. So basically, they were looking at Sandcastle Towers housing development as sort of as a housing opportunity for their clients. And they noticed that the housing development had a blanket ban, which will go into those practices. But they basically had a blanket ban, which basically said that they would house no one who had any sort of arrest or conviction record, regardless of any factors. And so what Fortune Society did is that they challenged that blanket ban because they were not allowing people with arrest and conviction records to live in their housing development. And they saw it as a civil rights law that was in violation of the Fair Housing Act, because as we may know, arrest and conviction records, the majority are overwhelmingly Black and Hispanic. And I would even say it can include the disability community as well, but they were focusing on the race part of this. They saw that this ban would disproportionately and overwhelmingly impact Black and Hispanic households since they have a higher arrest and conviction record rate. So these are just some additional problematic practices that housing providers often utilize when they're looking into arrest and conviction records. So having no time limits, permanent or blanket bans, which we saw in the previous slide with that example, unreasonably long look-back periods, minimum look-back periods, or unclear starting points. Those are just some of the practices that we see. And again, those can be problematic and could have a disproportionate impact, again, on certain protected classes like race, gender, ethnicity. You could even include disability in that as well. So eviction records, very similarly to arrest and conviction records, as I mentioned, we're really going to focus on that screening process. So with arrest and conviction records, a lot of the times, I'm going to go back because let me finish the arrest and conviction record before I go into eviction. So with arrest and conviction records, really that screening process. So a lot of housing providers utilize that third-party screening service. And so with using these sort of services, there is often missing information, inaccurate information, or if the information is there, it might not be up to date. So simply having a housing provider utilize that screening process without sort of having this conversation with the potential tenant of what the actual situation is could potentially lead to a fair housing violation. So simply only utilizing that process itself instead of having a conversation with the tenant and asking for more information could be problematic. So that's what I wanted to say when we're talking about eviction records right here, is that that similar screening process when it comes to background checks, when it comes to the arrest and conviction record, is very similar when we're talking about eviction records, because a very same process could happen when they're looking into a tenant screening, right? So if a person has even an eviction filing on them, again, it could be inaccurately, or there could be missing information when they're using this process. But before I jump ahead, I just wanted to provide some data when it comes to eviction records here in the U.S. And this is a study that was done by Eviction Lab. So it's found that in a typical year, landlords file 3.6 million eviction cases. And when they were looking at all these different court records, the study found that Black individuals made up only 19.9% of adult renters, but they actually made up 32.7% of all eviction filing defendants. So when you break that down a little further, 1 in every 5 adult renters were Black. However, 1 in every 3 eviction filings that were served were to a Black renter. And so again, we should see the racial disparities, we even see the gender disparities, because for the most part, Black renters who are facing evictions are oftentimes women of color, women who are the head of their households. Just some additional information here when it comes to eviction records. In Illinois specifically, about 72 families and individuals can lose their home every day. Again, this can have a lot of sort of trauma to the person, not only struggling to keep a job or caring for their family and staying in good health, but even securing future housing. So as I mentioned a little bit early on, that tenant screening, again, using these third-party services that housing providers use could definitely impact people and individuals from further securing housing simply because they have an eviction filing that never resulted in eviction. But because that eviction was filed, that could flag someone and even, blacklist them from other potential housing opportunities. So I'll be wrapping this up shortly, but crime-free ordinances, just want to touch on those quickly. And really, they're oftentimes called anti-nuisance ordinances. They really require landlords to evict tenants who place a certain number of calls to emergency services within a certain period of time. So we largely see this with those who are experiencing domestic violence or sexual harassment, but really it could be anyone. So maybe those who are older, people who may have a disability. Having these crime-free ordinances in place can impact a lot of the protected classes that we talked about today. So I'm nearing the end, but I think throughout our conversations today, I mentioned some of the few people that could be potentially held responsible for fair housing violations, in our scenarios and our examples, but I mentioned a lot landlords, property owner, property management companies, but it's also important to note that even housing associations and municipalities can be held responsible, as well as real estate brokers, appraisers, lending institutions, building developers, insurance companies, again, newspapers that post any sort of public discriminatory ads, and then really anyone else who may work for these other entities that I just that are listed and that I just said. So with anything when we're dealing with the law, there are certain statute of limitations for when persons are potentially filing a complaint. So with the Department of Housing and Urban Development, it would be 1 year, within 1 year. With the Illinois Department of Human Rights, it would be 1 year as well. And then with any federal or state court, it would be 2 years. And again, I will make sure to provide this sort of this presentation with you all after once the link is shared out as well. So I'm gonna go over this really briefly because I really want to talk about source of income. Well, I want Foluke to talk with you all about source of income. But here we kind of have just a flow chart of how how our process works when we get fair housing complaints. And so one of the first things we always ask people to do, it's sometimes hard to identify if you're experiencing fair housing discrimination. So definitely call our office. Our intake person will answer your call, sort of ask you some questions, screen if there's any fair housing issue at play, and really gather that any additional information they might need. And so from then on, she can decide whether or not, is this a fair housing issue, or if it's not. If it's not a fair housing issue, typically we refer it to another entity or another organization that can be better equipped can be better utilized to assist that person. But if it is a fair housing issue, again, think of that equation I kind of started off the presentation with. If you have a prohibited act in a protected class, it's likely that there might be illegal discrimination. Our enforcement team will meet, they kind of review that complaint and decide what sort of next step or next course of action is. And so here at Hope, we can do one of two things. We can do testing, which if you want to know more about testing, please feel free to reach out to me. But basically, testing is just this sort of covert way of gathering evidence and just a way to see if there's actually a potential fair housing violation, depending on what the protected class is and what the situation was happening. So again, if you want to know more about testing, please feel free to reach out. And then other ways that we might gather information are by witness interviews, property research, or even just collecting evidence. And then once our enforcement team decides that we have the necessary information, we are going to analyze that evidence. And so one of two things can result from that analysis. So there could be an informal resolution where all parties sort of agree on terms of resolution, or an enforcement action can take place. So this is where we would actually help the person and the complainant who calls sort of fill out this administrative complaint, file it, seek out any legal remedies, consolation, etc. So again, identifying if there is a fair housing discrimination occurring, or if you're enduring fair housing discrimination, can be a little bit hard to know right at hand. So definitely feel free to contact us if that ever occurs. And I'll just list the number on here and I'll just read it off as well. And I can follow up with additional information. But to contact us here at Hope, our number is 630-690-6500. If you want to contact HUD, the Chicago Regional Office number is 312-353-5680. And so now I'm done with my portion to kind of give you guys that foundation, as I mentioned. And so Foluke, whenever you're ready. I will hand it over to you.
Thanks, Jocelyn. Good morning. I'm like, is it morning? Yeah, it's still morning. Good morning, everybody. My name is Foluke Akanni. I'm with Housing Action Illinois. So Jocelyn just gave a great overview of like the fair housing protections. And I'm just going to dive deeper into this new sort of income protection law that was passed last year and just became effective this year. But I'm going to talk about who Housing Action Illinois is. But as a disclaimer, like Jocelyn also said in our presentation, this is also not legal advice, it's just an informational presentation about source of income. So Housing Action Illinois is a nonprofit that leads and expands affordable housing to end homelessness. So we've been around for about 35 years. We celebrated our 35 years anniversary last year. And we work in coalition with other organizations. We have about 160 members around the state of Illinois who also want to fight for affordable and stable housing and a place to call home in the state of Illinois. We also have, you can go to the next slide, Jocelyn. We also have 3 different types of teams that we have in Housing Action. We have the public policy advocacy team, which advocates for policies to end homelessness and to create affordable housing and promote sustainable home ownership in the state of Illinois. And then we also have capacity building team that helps to strengthen nonprofits and organizations that are part of our membership. We do trainings, resources, consultation, share those with housing counselors and other nonprofits as well. And we do education and organizing. We build awareness, we build awareness, we make sure that we're sharing stories of folks who are impacted by homelessness and also around housing insecurities. And we also hold our annual conference and working groups as well. You can go to the next slide, Jocelyn. So source of income, what does that mean? And when did this fight start with source of income? So advocates have been fighting for this to pass the source of income protection for almost 20 years. The House Bill 2775 adds source of income as a protected class in the Illinois Human Rights Act. This bill was signed last year by Governor Pritzker on May 24th, and then became effective this year. Next slide. So what is source of income discrimination? Source of income discrimination is basically when a landlord, a property manager, a mortgage lender treats an household unfairly because of the way they pay rent. So this could be any kind of non-wage income that you're using to help pay your rent or help to finance your home. So it basically means that that person, real estate agent or real estate actors in that transaction are refusing that household because of the legal means of how they have their income. You can go to the next slide. So when we were doing our source of income campaign, we kind of looked at different types of facts in the state of Illinois. And we found out that half of Illinois households receive some kind of non-wage income. If you kind of breaking it down here on the slides, 3,000 veterans who use VASH to avoid homelessness, you pay a non-wage income. Also folks who use housing choice vouchers, folks who also are surviving domestic violence, SSI individuals. So that's if you had different types of categories, also like folks who use child alimony, rental subsidies. That's half of Illinois use some kind of non-wage income to pay for rent. So we felt that this was an effective way, especially in our fight to kind of end homelessness and make sure that people have a stable housing. Next slide. So again, who does this impact? So these are folks who are trying to pay, a crisis happens and they try to pay their rent with some kind of rental subsidies or homeless prevention funds, housing choice vouchers, who can now use this their vouchers to use that as a means to pay their rent. without being discriminated against by the landlord. Folks who might have lost their housing choice vouchers because of their long wait in trying to find a landlord to accept their voucher. This is also a racial thing. If you go to the next slide, it's most of the time this also affects folks, Black women led households, folks with disabilities, folks who have children. This affects a lot of folks when we're looking at source of income and how it impacts like Illinoisans and people in general who use this non-wage income to finance their home. Next slide. So like I said before, this was definitely a long fight, a 20-year battle. And we did have some opposition. We had the Illinois realtors who were opposing this law to come into fruition. But we had a coalition. Housing Action Illinois is part of the Illinois Coalition for Fair Housing, and All Fair Housing is also part of that coalition. We had just people who helped to fight this bill to become law in the state of Illinois. We had over 160, I believe, 130 organizations who endorsed this work and supported this work, who also talked to legislatures, talked to their state housing representative and senators to help pass this. At the end of this, the realtors who were opposition to this for 2 years when we were fighting for this actually became proponents of this bill, and now it's in effect. So I just want to thank everybody, especially I think the sales network for also endorsing this and fighting for this as well. So I'm going to kind of dive into what this means. You can go to the next slide. So Jocelyn stated that there's federal protections, and then also Illinois has the Human Rights Act protections that has additional protections in the state of Illinois when it comes to protected class. Now, source of income is now a protected class for the state. So just like race, religion, disability, now source of income is now a protected class as well. Next slide. So this is what the law says and what the language from the bill says when it comes to source of income. Source of income means the lawful manner by which an individual supports him or herself or his or her dependents. So this verbiage we took from Cook County, who already had this law passed several years ago. And we used that law and that definition for the state as well, because we're going to be looking, in a few slides, I'm going to talk about looking at Cook County, who has had this law as guidance to how we interpret the law playing out in the state of Illinois. Next slide. So, so this law became effective this year, and we look at source of income as housing choice vouchers, veterans benefits, SSI, also emergency rental assistance, SSD, child support, homeless prevention funds. We have an extensive list of what we consider source of income. So again, source of income is a non-wage income, a non-wage income that you use to finance and pay for your home. Next slide. So I'm going to talk about examples of source of income discrimination. You can see this in either like a newspaper ad or like a Craigslist of like a Zillow, or I think Zillow is now tracking that too. But in any kind of ad that says no Section 8 thanks, that's now again a source of income discrimination that you can definitely reach out to Fair Housing for, or reach out to another fair housing agent to kind of report that. Telephone call that says we don't take a Section 8. If you're calling a landlord or calling a property owner and they say that they don't take Section 8, that is an example of discrimination. If someone says you have to have a job to rent here, again, that is a form of discrimination. If you're calling and you're filling out an application and the landlord or property manager or the real estate actor says we don't take township rental assistance, that is another source of discrimination. Just having a blanket policy that you don't take rental assistance of any kind, or emergency rental assistance of any kind when you're looking to get housing, that is a sort of a discrimination. Landlords who also refuse to, if you have a housing choice voucher and you're trying to get a home, but the landlord says they don't want to sign a contract or allow property inspectors to come into their home because of your subsidy program, that is source of income that's a sort of income discrimination. Also, landlords who want discusses like background check for because you're a voucher holder or because you're using non-wage income to pay for your rent. That is again an example of discrimination. Folks who landlords or property managers or whoever who charges extra for application when you're filling out to get a home. That is again an example of discrimination. Landlords and property managers that say that you need extra insurance if this individuals went into a domestic violence agency. That is another example of source of income discrimination. Landlord who require SSA participants to prove that they will receive income for the duration of the lease. That is an example of discrimination. And landlord who tells they look at their credit score is low. A landlord that tells the applicant that their credit score is too low and doesn't want credit checks for people who with child support income. That's also an example of discrimination as well. A lot of questions that we get is when doing this type of presentation is housing choice vouchers, is it mandatory to rent to housing choice vouchers holders? The simple answer is no, but it's not mandatory, but the law does require, just like in terms of race or disability, you to treat a tenant or the applicant equally when it comes to the evaluation screening of that process. So an example that I usually say is that if you have a person who has a voucher and another person who doesn't have a voucher, and the person who has a voucher has a bad reference and the person who doesn't have the voucher has a good reference, and the landlord is looking at both candidates equally, but because of the references chose the person without a voucher, then that is looking at the process equally, and that's not discrimination. But if the landlord is looking at both the voucher holder and the non-voucher holder, and the voucher holder has a good reference and the non-voucher holder doesn't have has bad references, but chose the bad reference non-voucher holder, that is called discrimination. So again, just thinking about treating every applicant equally when it comes to that process. No, you can go back. Thanks, Jocelyn. So we again took the definition that Cook County has when it comes to source of income, and the Cook County gave a guidance of what they meant by source of income, and also what they meant by source of income. And when you're looking at this guidance that Cook County has, because again, the definition in the law, in the bill, has the same definition as Cook County. So we're looking at as what Cook County says and giving guidance as how we would look at the state law in comparison. So Cook County includes 3 times the rent as part of source of income. So again, someone who has let's say someone has a rent that's $1,500, and then they have a voucher that's $500, and they're applying to get a rental unit. With 3 times the rent in that ad, the person will be only responsible for that $500 with voucher. So if you times that by 3, the housing choice voucher holder is only able to, that 3 times the rent is only $1,500 rather than $4,500 for that 1,000. Is not paid for the 1,500 portion of the rent, just the voucher portion that the voucher's holder is responsible for that voucher. Hopefully that makes sense, because I kind of was looking through it. So just, I guess, what to take away from this is that if there's an ad that says 3 times the rent, the voucher holder is only responsible for that for what their portion is for paying. If the voucher is if the tenant, if the voucher holder is paying $500 a month for their portion, that is the 3 times the rent that they're available, that they're responsible for, not the entire rental amount. Next slide. So with this now becoming into law, this changes things for renters and for folks who are financing their home with their non-wage income. Again, we're referring to folks who use child support and alimony, healthcare workers and service industry workers who, again, were refused rent because of their occupation during COVID. Again, we're looking at considering emergency rental assistance. This is also related to folks who needed that rental during COVID and might still need it even during this process. And then we're looking at, again, examples of landlords and property owners who don't want to complete paperwork when it comes to making sure that someone is housed. All of this are listed as source of income discrimination. And I will talk about in the next slide what you can do to kind of document that and then also advocate for yourself and for the people that you serve. Next slide. So if you have seen any kind of source of income discrimination, you just want to note and document who you spoke to. If it's the property manager, if it's the landlord, if it's the real estate agent or whoever it is, want to know who you spoke to, the address of the property that you were applying for, and what that person said. You can just give like a statement or summary of what that person said, what happened, if the person said no Section 8 or just refuses because of the paperwork, you can kind of state that. You can save any kind of emails, any kind of voicemails that was left, save that and document that as well, or any kind of ad listings that list any kind of discriminative language in their ads. You want to save that as well. And then you want to contact your local fair agencies and have those documents ready to go as well. Jocelyn, again, Fair Housing is a great resource to reach out to if you want to kind of take the next step and look at if this is something that affected you, someone you know, your neighbors. You want to make sure that you've documented this and then reach out to Fair Housing or any kind of fair housing agency in your area. Next slide. So these are, again, different types of housing, fair housing agencies. All these agencies can do intakes and can help if you're faced, if you've been a potential victim of source of income discrimination. So I know that Hope Fair Housing, because they're here doing this presentation with us, and I know that Springfield is one of your service area. There's also South Suburban Housing Center, Open Communities, Perry State Legal Services, and then Metropolitan St. Louis Equal Housing and Opportunity Council. All of these agencies help to make sure that folks are abiding by the fair housing laws. Next slide. Again, there's I kind of just want to encourage everybody. I know sometimes advocating for yourself and others can be a lot, but it is good to kind of make sure that you're taking actions, especially when it comes to making sure that you are speaking out for yourself and for others. Again, with taking, especially with source of income, if you have faced that, I know it can be emotionally tolling for people, and then it might cause some kind of expenses because you're going from place to place trying to find housing. But you want to make sure that people have a way to kind of, again, advocate for themselves. There are different remedies to make sure that you as an individual or your household is being made whole when it comes to facing this kind of discrimination. And there is different types of monetary damages that can be filed against that landlord or property owner or that bad actor when it comes to those discriminations as well. So again, just wanting to make sure that folks are I'm encouraging people to take action when you do face this and making sure that we had noted this so that also when we are talking to the Illinois Human Rights Department, that we're making sure that they know what's happening in the ground and able to also enforce this law as well. Next slide. I think that's all I have. I know there might be questions. Feel free to put the questions in the chat. If folks have any questions, then we can, Jocelyn and I can definitely tackle those questions as well.
There are a couple questions. First, what is the difference between a service animal and an assistant animal?
Sure. So assistance animal, that's the term that is utilized when we're talking about fair housing. So it incorporates emotional support animals as well, whereas, and this is kind of where it gets confusing because you probably, a lot of us here, housing providers, sort of interchange assistance animals and service animals. They kind of interchange and use those two terms interchangeably, I should say. So service animals are accommodated in public settings, whereas assistance animals, again, we're referring to, it's more inclusive when we're talking about fair housing because it incorporates those emotional support animals. So hopefully that answered the question.
Okay, and the other question, what does a tenant need to do to break a lease as an Illinois resident due to being stalked or harassed without penalty?
So depending on the type of housing the person is in, at the Illinois level, we have the Illinois Safe Homes Act. There must be credible imminent threat in order to enact the Safe Homes Act. And then we also have VAWA, which is the Violence Against Women's Act, which is at the federal level, and that incorporates more of the. Let me backtrack. Illinois Safe Homes Act includes all housing except public housing, whereas VAWA at the federal level does not include private rental housing. So that would be subsidized housing, Section 8, things like that. So again, there must be a credible imminent threat in order to enact those. And if you want more information on the actual process of how to go about that, I can definitely get that information for you. But I know that the key thing here is that there has to be a credible imminent threat. So if something happened on the premise with this individual or the tenant, if the person knows where they live or has knows where they live, or they have gone to their place of employment, you know, sort of making these threats to them, then, and just fearing that they might lead to having them be at their home, that those would be cases of credible imminent threat. But yeah, Safe Homes Act and then the VAWA, depending on the type of housing situation you're in.
That is all the questions I have.
I have a question. Have you seen many complaints coming in where landlords are refusing to accept vouchers?
Yeah, so I think we are starting to get calls. And again, I think one of the things Foluke, and I'm not sure if you did mention this or not, Foluke, one of the things that we as a fair housing agency are dealing with is kind of the actual process of going about how are we helping individuals, you know, sort of document their sources of income, because, you know, a lot of these sources of income aren't necessarily from a pay stub, right? But they are legal methods in which people are getting income. So that's one thing we are trying to navigate here as a fair housing agency, kind of creating that resource for people to utilize. But also, again, we're not getting much guidance from the Illinois Human Rights Department in terms of how to go about the process. So we're kind of waiting on that, and we're just really evaluating everything on a case-by-case basis, but still hoping that that guidance is pretty much the same of what Cook County Human Rights Ordinance has, that, you know, they'll include vouchers, that how voucher holders, the income is used for vouchers would be the same throughout the state, and then just other sources of income. So yes, I think we have been receiving calls. Again, if people are enduring this, or maybe your clients are, or there's some sort of issue or any sort of fair housing matter, definitely call, because again, trying to navigate with fair housing discrimination can be very tricky, and identifying it can be hard. So definitely call if you're unsure. So we just keep encouraging people again to really just call us. Source of income is very new at the state level. So I think people are still unaware that it's a protection added to the Illinois Human Rights Act. So that's kind of why Foluke and I are here, to make sure that people know about this new protection, and that it impacts, a good portion of residents here in Illinois, not just voucher holders, but again, those who receive SSDI, SSI, veterans, families, mothers who receive child support, things like that. So definitely just want to make sure people know about that information, and contact us if anything.
Well, I know just yesterday here, I was reading an ad here in Springfield on my Facebook group, and the landlord had specifically said no Section 8.
I think that's the things that we want folks to report if you do see that, and flag that. So I know that there is still folks who are saying those languages and putting those ads out, but it is now against the law. So folks can definitely flag that and let either Hope Fair Housing know, or like either you can also reach out to IDHR and flag those as well.
Okay.
Well, there's one more question. I believe you've just addressed it. Lisa says, I recently assisted my consumer to move into an affordable apartment. While meeting with the property management, she said, just in conversation, we don't accept Section 8. She says, should I give them information about the new law? Yes, Lisa.
Yes,
absolutely.
And I think we forgot to share this. We do have fact sheets for both tenants and landlords, and we can share that afterwards to share with the group. But definitely maybe to print those resources out and share with anybody that needs those resources, because that is, saying that out loud, that is discrimination.
Yes. Yes. Send that fact sheet when you send your slides to me, and I will share the recording and all the slides in the fact sheet with the group.
Okay, perfect. And I'll also, for whoever asked about the sexual harassment, I can send more information about that as well, if you don't mind sharing that. But yes, we have fact sheets. We'll also, I know I saw something in there about the PowerPoint. We will be sharing our slides once that link is sent out. So be on the lookout for that to kind of go back on.
And another question just came in. Esther asks, for source of income in the form of alimony or child support, suppose alimony or child support is ending in 6 months. Is the landlord bound by the new regulation of source of income discrimination?
Again, it's how the landlord has to treat anybody who accepts any non-wage of income fairly throughout that application and the application and screening process. So again, that has to be equal and fair treatment. I don't think you have, again, fair equal treatment of all tenants. The amount of money or when that money ends or when that voucher ends is not taken into consideration. Is how you treat that person and making sure that at that time of the rental that you're treated them fairly and that they have that funds to, you're looking at the funds that, you look at the entire funds and how you make your decision.
Yeah, so basically what we're saying with source of income, and we're hoping that it's kind of put into place, is that someone simply should not be denied housing because of how they're receiving their income, even if it's within the legal matters of how they're receiving it. So even like Foluke said, sorry, even if it's ending in 6 months, that's still a way of how they're of their income right now. So they should not be denied simply because they're receiving child support or alimony. We just want it to be fair. We want everyone to have the same opportunities. Just because they have different ways of receiving income should not impact how they're able to secure housing. Again, just making sure those are legal sources of income. Do we have any other questions? Oh, sorry about that.
I do not have any questions in the chat or in the Q&A at this time.
All right, well, we know source of income is new. We're still trying to make sure it's implemented in the way Cook County kind of has it. We're hoping that it follows that same sort of guideline. So we definitely know that this is a lot and it's new information. So if you have questions, please feel reach out to our respective organizations if you have anything else. If I see
Just-
there's a
Yeah, one quick one. Is there any changes in housing sex offenders or felony in low-income housing? In housing for sex offenders?
in housing, sex offenders, and felony and low housing.
Yeah, I don't think anything has changed, but I would definitely, we can look into that and get back to you. But I don't feel like that has changed when it comes to public. Are you talking about public housing? I don't think that has changed when it comes to public.
Yeah.
Housing. But we can definitely get back to you about that.
Here we go. There's no protections for folks utilizing vouchers and other federal subsidies.
Through this law, through this law, you are protected as a voucher or if you use rental subsidies. Is that what the question is about? Or
Nafia commented, as a sex offender, if they're registered. Right, Nafia, there's no protections for folks utilizing vouchers? Yes, she says.
okay,
Yeah.
okay.
Okay, I thought she was answering the question above. I was like, wait, I'm a little confused.
Yeah, I think she was. Yep. Thank you, Nafia.
Thanks, Nafia.
Yes. So,
Okay, if we don't have any,
Okay,
I'll turn it over to John.
okay, again, we don't want to cut anyone off, but you will have both Nafia and Foluke's information when the slides are sent off. So if you go to bed tonight and something hits you and you have a question, feel free to reach out to one of them or either to Shelley or myself, and we'll be happy to get the answer to you. But we want to thank you for tuning in this morning to this webinar, and on behalf of Shelley and Silk and myself and Enzo, we want to thank Foluke and Jocelyn for their presentation. And again, if you have any questions in the future, please reach out. And again, have a great day. Thank you again. I think that ends our webinar.